Everyone. My name is Melissa Kallio. I am an attorney. I practice at the law firm called Dutton, Casey and Mesoloras PC. We focus on elder law, estate planning, guardianship, probate, and a lot of that includes doing long-term care Medicaid planning, long-term care Medicaid applications. So this presentation is kind of a nice way to go about reviewing that information and looking at it in a little bit different of a way through kind of a myth and not myth kind of series of slides. So I welcome questions. Please use the chat. I'll try to get to them as we go through the presentation because I find that it's better if I answer a question that's on topic rather than kind of bounce around between them. But I certainly do welcome your questions. So let's go ahead and dive in. So let's start with just kind of a primer of what is long-term care. Kind of logical, I think, in a lot of ways what long-term care is, but it's medical and non-medical care given to people who are unable to perform their basic activities of daily living or ADLs. We see long-term care being provided in all sorts of settings at home. Or in a long-term care setting like an assisted living or a skilled nursing home. So I work with families who are trying to make it work in really all of these different settings with, I can say by far and away, most people approaching me and saying, I would like to be able to have my long-term care provided at my home. That's usually everyone's preference, and we work as best as we can to try and make that a reality. But when it becomes not a reality, or if just from the very beginning we need to look at a long-term care setting, very commonly working with families who are dealing with assisted living facilities, skilled nursing homes. I also work with people where maybe a person is living in more of a group home arrangement, like a community integrated living arrangement or a SILA. We also do work with people in supportive living facilities or also just kind of your memory care facilities. So there's a whole host of different options for people and just kind of depends on where the person is at and what they need. This can be needed at any age. Unfortunately, my clients are not just, advanced age, so to speak. I see people all across the spectrum who need long-term care for a variety of reasons. It's not limited to just one age group. And there are different facilities and different settings that may specialize in certain age groups or certain diagnoses. So I think a big key for this is that Medicare and most health insurance plans are not going to pay for your long-term care. We'll talk about this later, but Medicare has a limited benefit. And most of your health insurance plans just simply do not cover the cost of long-term care unless it is a long-term care insurance policy itself, which is just a policy that's specifically designed for that type of care for a long-term care setting. So activities of daily living. I mentioned this on the previous slide of this is something that not being able to do these things can kind of trigger your need for a long-term care setting. So this is some examples of them. Driving, meal prep, bathing, toileting, dressing, transferring from bed to chair, etc. I would say that by far and away when I'm working with families who are maybe looking at a transition from this care being provided at home to the care needing to be provided in a facility, by far and away it seems to be the thing that kind of pushes them to a facility is this last bullet point, right? Transferring from bed to chair or other types of transfers. And what I see with a lot of people there is that it's like, okay, I've got the one person who can do the driving, they can do the meal prep, they can do the bathing, they can do the dressing and the toileting. But when it comes to actually having to physically move someone and maybe you don't have devices or machines that are that can assist, that really becomes a barrier for a lot of people to be able to live at home if they need more than one person to assist with transferring for various activities. So I think that's in my experience, what I've seen kind of really pushes people into more of a facility setting is just that inability to safely do transfers at home. So now that we've kind of set the stage, I want to get into the we've got a series of, I think I did 10 myths, and then we'll kind of dive into why each thing is a myth. So we'll start with myth number one. Medicare pays for it all. That is a myth. That is not true. Medicare does not pay for it all. So in reality, Medicare will cover up to 100 days of skilled nursing care. We put the emphasis on it, but I'll point it out, up to 100 days. That does not mean the 100 days is guaranteed. Medicare has certain standards that have to be continued to be met for a person to get Medicare to cover their nursing home. And so if you're not continuing to meet those standards, you could be up at day 20, you could be up at day 30, or you could truly meet those standards all the way up to day 100. It just depends on your situation. And this facility also has to be a Medicare certified nursing facility, a facility that is approved to receive payment from Medicare. And this also has to follow an inpatient hospitalization of at least 3 midnights. So you've got to meet those requirements to even get it in the first place. Medicare will pay the full cost of the first 20 days, but then you're going to have a copay for days 21 through 100. Usually, if you have a Medicare supplement plan, that policy is going to cover that copay. I've had a lot of people who have come to me and they have said they don't have a supplement, but they're still on Medicare. Well, the reality is that that copay might be something that they can't pay, and they might have to start planning for other types of coverage, for example, Medicaid, to assist in covering those days. So think of it as full for the first 20 days and maybe covered in full if you have a Medicare supplement that covers it for days 21 through 100. Medicare has a pretty limited home care benefit. You're gonna have to need intermittent skilled care at your home, and it's typically only after a hospitalization. The key with this though is that it's not going to include custodial care, right? Which is the type of long-term care most people who are impaired by dementia require. So this is really just for intermittent skilled care services. So a limited benefit, and it's usually not the answer long-term. Kind of like it's not the answer long-term in a skilled nursing setting either. You have to kind of plan for and determine what your next step is going to be once these forms of coverage end. So Medicare does not cover it all. Medicare does not cover it all is the answer to that. If you hear someone saying Medicare will cover it, that is a myth. Unfortunately, I do still see a lot of people who come in and consult with our office and think that that is the case. So I think the word is somewhat out there, but not completely, because I do still see way more people than I should who are coming in and saying, well, Medicare will just cover everything for me. I'm good. So definitely a myth that it will cover everything. Okay, so myth number two. I have gone back and forth on maybe whether we should change this slide up a little bit, and you can make your own judgment call as I go through it. So myth number two, long-term care insurance is only for the young and rich. Time and time again, I've been hearing from people who have come in and we've maybe talked about their overall situation, and we've talked about long-term care insurance, and they've literally just said, I just can't afford it. And they're not people who, I would say you would just at a glance think can't afford it. So this is kind of something that might be teetering on the edge of actually being a myth at this point. So long-term care insurance in general is an option for almost everyone. It's going to be your only health insurance that pays for custodial long-term care, either at home or in a formal care center. So years ago, I would see really, really nice long-term care insurance policies. I would see clients who would come in and they would have long-term care insurance policies that really were just unlimited policies. And I think what we saw happen was these companies got really burned by those policies. They had people claiming on these kind of unlimited benefit policies for years and years and years and years. And then they started to not be able to pay for all of the people who they had insured. And that then in result had them come up with policies that have all sorts of stipulations and all sorts of strings attached to them, to kind of, in a classic way that insurance works, makes things a little bit harder for them to actually pay out benefits. So some things to look for if you are considering a long-term care insurance policy. So I highlighted a few of them here. I'll point out the max daily benefit and the max lifetime benefit. So be very aware of how much you can actually get out of the policy. Most policies I'm seeing now have a maximum lifetime benefit. So maybe they say, okay, as a policy, we are going to cover up to $300,000 over your total life. Well, that's all well and good, but also pay attention to whether they have a daily benefit. So just because you have a max benefit doesn't mean you're just going to be able to get that as you need it. You might be maxed out on how much you can get per day. You also really would want to make sure that your policy is going to cover what you want it to cover. So, for example, some may not cover home care costs, the costs of providing this care while you are still at home. They might have a very robust assisted living or skilled nursing facility benefit, but they might not cover home care. So something to kind of be mindful of, you might want the flexibility in the policy to be able to cover more than one type of care setting. Some will allow for spousal portability, which means you can basically transfer the benefit between spouses. The premiums, I think the premiums are the biggest barrier for many people. And they say that premium, I just simply cannot afford it. So you might want to be mindful of, okay, is there a policy where maybe the premium is fixed? It's not going to change. It's not going to go up every year. Maybe it's a fixed premium, something to look out for. Some policies are still doing a combined long-term care insurance benefit that includes life insurance. So it's kind of a combination policy. So I say to people, if this is something that you are considering, talk to the insurance broker. That's going to be kind of the starting point for trying to get a policy that you can afford, and that's actually going to cover what it is that you need. I think on my end, it's kind of still something I'm continuing to evaluate whether we should still be saying that it's not only for the young and the wealthy. I do hear time and time again that these premiums are just a lot of people just simply just cannot afford them. I think long-term care insurance, with what I've seen, has done a really nice job for people in bridging the gap. I've seen people who, because they had a long-term care insurance policy, were able to stay at home longer because they were able to tap into that benefit. And as a result, their savings did not go down as quickly. I've seen people be able to use it so that they can stay in a different care setting that they want to stay in before transitioning to the type of setting that would need Medicaid to pay for it. So, for example, in a non-Medicaid certified memory care facility, the home care or the benefit from their long-term care insurance policy allowed them to stay there longer before they had to go to a skilled nursing facility and apply for Medicaid. So it has worked out really nicely for a lot of my clients and allowed them just some flexibility in being able to go after the care setting that they would like, as opposed to their funds really dictating what they can do. All right, myth number 3. If I have long-term care insurance, I will never need Medicaid. That's a myth, because the only way it could ever be true is if you had a long-term care insurance policy with an unlimited benefit, both daily and lifetime. And I have never seen, at this point, I'm not seeing that anymore. I would be shocked if there were policies issued. And if they are, I would be shocked to know what the premium is. So it has its limitations. So it's not a guarantee you won't need Medicaid. I think where it has been very nice is kind of in the circumstances that I just talked about, allowing people to remain at home or in a care setting that they want to remain in before the policy is exhausted and before their savings is exhausted, such that they they end up having to apply for Medicaid. So it has its limitations. It's not a complete bar to avoiding a Medicaid application in your future. Myth number 4. Medicaid is a federal program and is the same in every state. That is a myth. So while it is a federal program, it is not the same in every state. So it's a combination of both federal and state efforts. So you've got joint funding. So both the federal government and the state governments fund Medicaid programs. But then the states are the ones who are actually doing kind of the nitty-gritty work, right? So they are the ones who are reviewing applications, approving people for benefits, and then actually going and paying the provider for the services that they're providing for the Medicaid eligible person. So it's a joint effort, and the federal statutes, the federal law sets forth the basic requirements, but the states can deviate from that. And as a result, we do have differing programs between states. One of the biggest areas that I do see differences in between the states is something called the look back period for a Medicaid application in a long-term care setting. So the look back period is how long or how far back the Medicaid agency can look at someone's finances in determining whether they're eligible. So in Illinois, that's 5 years. I know that for example, when I had a person move from Florida to Illinois, they were on Medicaid in Florida, and in Florida, they only looked back 3 years. So I think we see differences in the look back. We see differences in how much the spouse who's living at home can keep between state programs. So just because you are approved for Medicaid in one state does not mean that you will get approved for Medicaid in the next state. And you also will have to do a completely new application if you move to the other state. There's no way to just transfer your coverage. I've had this a number of times. The best example I can give is I had a woman who was living in Florida. She was in a nursing home in Florida. She moved up to Illinois to be closer to her family. She was on Medicaid in Florida. The day that she got here, we applied for Medicaid for her in Illinois. Illinois has no durational requirement, so she did not have to be here for a certain amount of time in order to apply. We applied the day that she got here. So differing programs, different applications, could be eligible in one state and not be eligible in another. All right, myth number 5, Medicaid pays for care no matter where I am living. So in reality, Medicaid pays for the types of settings that it has approved to pay for. So in the community sense, so if you are living at home, there is just something called Community Medicaid Medical. So it's just Medicaid coverage for your health needs, your prescription needs, your doctor's appointments, your hospital bills. It's essentially just like a health insurance plan. That's community Medicaid. But the thing about community Medicaid is that it's not covering the services and supports that we think of, when we think of what is provided in a nursing home. Medicaid will cover the cost of long-term care in a skilled nursing facility that they have certified, and also in some other settings under this waivered services. I do want to comment though on the skilled nursing facilities. You will see some skilled nursing facilities will say they are simply just private pay only. They have not been certified by Medicaid. You cannot go there and go on Medicaid. You must private pay only. When you are out of funds, you have to leave. There are some skilled nursing facilities that are maybe partially certified for Medicaid. So Medicaid has to certify the beds at the nursing home. So it is possible that at a given skilled nursing facility, Medicaid has only partially certified it, meaning maybe half the beds are certified for Medicaid. So if you are someone who's looking at going to that facility and you say to them, I need to go in and I need to go on Medicaid right away, you have to make sure that where they are going to admit you is actually a Medicaid bed. It's possible they say, well, if that's what you need, we have a wait list for our Medicaid beds. We have private pay beds open, but we have a wait list for our Medicaid beds. Then you will have skilled nursing facilities where every single bed is certified for Medicaid, which then poses the least amount of barriers for someone to go there who needs to go on Medicaid right away. Kind of want to carve out from the skilled nursing facilities a couple of facility types: assisted living facilities and memory care facilities. So, assisted living provides a lesser level of care, and that is not a Medicaid covered type of arrangement. Memory care facilities generally are not Medicaid covered. There are a couple in Illinois that do have Medicaid approval. So in general, no, but there's a couple of exceptions to that. So be mindful of asking that question if you are exploring facilities and Medicaid is in the future. I've had people who have said to me, found this facility, doesn't accept Medicaid. We've got some money to private pay and we really like it. So we're going to ride that out as long as we can with the available funds. And then we will transition to a Medicaid facility, once those funds are somewhat spent down. And that's just personal choice. Some people say to me, I'd rather not have to do a move. And so I want to just go somewhere where that transition can happen right there instead of having to move to get the coverage that is needed for Medicaid. So waivered services. So a waiver is where a state receives special approval from the federal government to provide care in a setting that is not the traditionally approved skilled nursing facility setting. So these services look like, so for example, supportive living and facilities for intellectual and developmental disabilities. So these are actually still facility settings. But they are facilities that are not skilled nursing facilities. So supportive living is more akin to assisted living, in that it provides less than 24/7. And a facility for intellectual or developmentally disabled is more of a, like, think group home type setting. So different types of settings, but Medicaid coverage for the room and board at those settings. So it's a nice alternative to your traditional skilled nursing facility because not everyone needs that, but they still need Medicaid coverage of their kind of room and board and care that they are getting. The community care program and in-home services are Medicaid waivered services provided to people at their homes. So you would have to, if that would be something you're interested in, this is different from my first bullet point of the community Medicaid medical. This is providing things like caregiver support, and different programs to assist that are beyond just hospital, physician, medical, prescription bills. And so the community care program is for people who are over 60, and in-home services is for people who are under 60. And these are separate programs that you would apply for. They will provide care and support, but there are limitations to them. So neither of those programs are going to provide 24/7 care and support to someone who is living at home. And that's kind of where that benefit taps out. But these are these are the most common things that I see in terms of coverage for Medicaid coverage for different types of settings that we could find ourselves in. All right, I'm going to take a quick look at the chat. Okay. So there was a question and it was basically answered very well. So I'll just kind of point this out. Are assisted living and supportive living facilities the same? And then there was an answer that was fantastic. So I'm just going to read it. Assisted living is private pay and you can pay for extra services. Supportive living is paid for by Medicaid waiver and has fewer services available for activities of daily living support. So fantastic answer. How are community care and in-home service care programs different? The biggest thing for me is just the age demographic that they serve. So you have the community care program for people who are over 60 and in-home services for people who are under 60. So that to me is the biggest distinction. And they will formulate a service plan based on what the person actually needs. So I think, that's the biggest distinction between the two of them is really just the age group that they're servicing. Okay. And get back to my screen. Okay, so myth number 6. All right, so Medicaid is for everyone. That's a myth. So let's talk about who is eligible for Illinois Medicaid. And I'll put this with just the disclaimer that I think I have probably two or three presentations that are just completely on Medicaid, all of the requirements, all of the details of it. So it could be a whole presentation in and of itself. So only residents of Illinois are eligible for Illinois Medicaid. So you have to be voluntarily living here, and but there's no durational requirement. As I mentioned in my other example, you could move here and apply the same day. You've got to have an intention to remain here, though. And so if you're maintaining a home in another state, so for example, my lady who was in Florida, um, so if she had continued to maintain a home in Florida, we might not have been able to argue that she had an intention to remain here in the nursing home that she was in. So you've got to be voluntarily here, and you have to kind of have an intention to remain. You can't just kind of show up and say, "Hey, cover me. I'm probably going to go back." It's kind of doesn't really work that way. So U.S. citizens or lawful aliens are eligible. So this includes people who are admitted for permanent residency lawfully. And when you do apply, you will have to provide proof of U.S. citizenship and identity. So it's part of the process. I know there's probably a lot more detail to go in on this particular aspect. It's not something I see routinely being an issue for the clients that I am working with, but I know there's kind of a lot more details to go into on coverage for people who maybe aren't citizens or lawful aliens, and what the state can still do in those situations. Okay, asset limitations. So Medicaid is a needs-based program. So they're going to evaluate someone's asset and income situation when they apply for benefits. So well, let's start with what they don't count. So for a single person, you can keep $17,500 in assets. Let's just disregard it. That's how much you can keep. Your home is not going to count towards that if you live in it, or if you intend to return to it, or if it's occupied by certain people. And those people can include your spouse, your siblings, or a minor or disabled child. But otherwise, if you are not living in it, it is not occupied by any of those people, and you have no intent to return, then it is going to count towards your $17,500 asset limit. Your personal effects or household goods does not count towards the limit. One motor vehicle. It's going to have to meet some requirements, though. Necessary for medical transportation, modified for your use, or transferred to your community spouse, or if it's worth less than $4,500. If you have a vehicle, it doesn't fall under any one of these exceptions, and let's say it's worth $14,500. They will exempt $4,500 of it, meaning that you've got $10,000 of a vehicle that counts towards the $17,500 that you can keep. Life insurance policies that are term life insurance with no cash value. These are the types of policies that you just pay a premium on, and if you wanted to get anything out of it while you were still alive, you wouldn't be able to. On the flip side, a whole life insurance policy, if it's over, I believe we're at 1,500, the cash value of it will count towards your asset limit. So practically that can kind of force a lot of people into surrendering the policy and grabbing the cash value from it, even though there's a much greater benefit if it were to be in place when they passed away. Burial funds and burial space and merchandise. So a burial fund does have to meet certain requirements. The typical ways that it is done is there is a trust arrangement with a funeral home, where you can deposit funds, and then those funds are used for the cost of your funeral and burial at your death. Or you do so through a life insurance policy that then pays out for the cost of your funeral at your death. It's a type of life insurance policy that is specially designed for this purpose. It's something you can qualify for even if you have health conditions. And as long as the requirements are properly done, when it comes to that life insurance arrangement, it's unlimited. So you can dump as much money into it as you would like. Burial spaces and merchandise are separate from the burial fund. So this includes things like if you're doing a burial, includes the casket, includes the arrangements for opening and closing the gravesite. So it carves out actually a lot of very expensive items such that it doesn't count towards any limit that could apply to your burial fund arrangement that you're doing. So that is usually when I'm working with people, probably my number one question is, do you have that prepaid? Because that's something that if we have people who are looking at Medicaid, who are maybe a little bit off from being eligible, we want to make sure that we get that done because death is inevitable and the cost to die is not cheap. So we always like to make sure that we get that covered. So I will move on to the next myth, although I did see some chats come through and it's just not letting me look at the chat on my screen. Let's see if I can do it here. Okay. So there's a question as to whether asset limitations are different for other states. Yes, that is correct. Different states can be different. States can be different. And it just depends. I think where we see a lot of the difference in a state is when we start talking about how much a community spouse can keep. So I think that might, that doesn't segue into this myth, but I want to just kind of comment on, there's an allowance allowed for a community spouse, and the federal government sets an allowance limit, and it depends on the state. So you could have a state that matches the federal allowance, but you could also have states that are below the federal allowance. So it just depends on what state you're in. Okay. So the next myth is I can hide my assets in a safe deposit box or in the sofa and they won't count it. That is a myth. Anything that you own is counted towards your asset eligibility. So I once had an application where we were probably 90% through the application process, and the child of the applicant called me and said, "We're moving my dad's couch." And I discovered that it looked like one of the couch cushions had been cut open and sewed back. He's like, so I opened it up and I found $20,000 worth of cash. And his father was the type who didn't like to keep money in the bank. So he wasn't exactly surprised by this, but it was just more concerning of we had gone through a significant amount of the Medicaid application, had them eligible, and now this money was going to impact. So the reality of it is that when you are applying for Medicaid, they will ask you, do you have cash on hand? So cash on hand includes the money in your couch, it includes the money in your safe deposit box. I have had people say, well, if I just withdraw this money, then I'll be eligible, right? And I'll say, well, but then you have to report the cash on hand. So withdrawing it from the account doesn't actually really help you. So if you were to take some of your cash and say, you know what, I am going to take this, I'm gonna buy, some gold bars, or I'm gonna buy some gold jewelry. That's something they're gonna count the appraised value of that. It's different if, let's say, you had a valuable piece of jewelry that was a family heirloom or a valuable wedding or engagement ring. Those types of things they're not going to count. Those were family significance, and those were things that you didn't just take your money and try and convert it into another asset. But if you did something different, like I talked about, where you're taking your cash and you're just buying gold bars in an effort to try and qualify, they're going to count those gold bars. With your safe deposit box, this is actually a specific question on every single application. They want to know what's in it and what the value of anything in it is. Most of the time when I have people, we're reporting a safe deposit box, but we're basically just saying it's got important papers, right? It's got original birth certificates, original documents. But if you've got coins or things like that, they're going to count the value of those things towards someone's eligibility. So moving it out of the bank account and putting it into the safe deposit box or into the couch doesn't actually do you the good that you want it to do to be eligible for Medicaid. All right, myth number 8. I have too much income to qualify for Medicaid. So in reality, and I think this is another one where we see a lot of differences between states. And if you, in doing like a simple Google search or through one of your AI tools, you might commonly come upon um, descriptions of Medicaid having an income cap for people who live in skilled nursing facilities. And there are some states that do have that. Illinois is not one of them. So the rule for income eligibility in Illinois is that if you are in a long-term care facility, your income, as in the person who's applying, just has to be less than the cost of your medical expenses. So when you think of a long-term care facility, could cost $10,000, $15,000. As long as your monthly income is less than that, then you qualify. So it's not capped by any sort of the means. It's just, it has to be less than the cost. Now, it's different if you're looking at eligibility for a Medicaid program outside of a long-term care facility. And so it's going to be different there. But in a skilled nursing facility, it is just less than the cost of the facility. Another big myth, a big one that I see, and I think even your long-term care facilities, the people who work there are confused about this too. So if there is someone who is applying for Medicaid in a long-term care facility and they're married and their spouse lives in their home, um, we don't count that spouse's income in this equation here. We look at just the spouse who's in the nursing home and we say, is their income less than the cost? If so, yeah. If yes, then they qualify. It doesn't it doesn't matter if their spouse has a lot of income or is working. Their income is not considered available to their spouse who's living in the facility. So that's really important. We don't combine their income to figure this out. We just consider the spouse who's in the nursing facility. And when Medicaid looks at this, they're going to do something called the name on the instrument rule, which means it's truly if there was a paper check being produced for a source of income, whose name is on it, and that's whose income it is. So very important, something I see a lot. I think there's a lot of misinformation, and I think the facilities themselves are even confused on it. It is the income of the spouse who is living in the facility, not the income of the spouse who is at home. Now, there are some other rules to that I think I'll kind of go into a little bit more while we stay on this slide. And that is, so the first thing is, let's say you have a spouse who's living at home and they say, okay, you're going to count my spouse who's in the nursing home, their income, but I need their income. I need their income to survive. So there's something called the monthly maintenance needs allowance, which says, okay, the general rule is this spouse who's living in the nursing home, they've got to send their income to their facility every month when they're on Medicaid. Because if that facility costs $15,000 and the spouse's income is, the person living there is $2,000, then there's a $13,000 gap, right? And that's essentially what Medicaid ends up covering. But if you've got a community spouse who's saying, well, I would like some of their income because I need it, Medicaid will evaluate that from this monthly maintenance needs standard. So they'll take what the community spouse earns and they will deduct that from the monthly maintenance needs allowance, which at this time is right around $4,000. So for example, if the community spouse gets $2,000 a month in income and they want to take from their spouse in the nursing home, they could take essentially $2,000 before they have to turn it over to the nursing home. So in my example, where the spouse who is living in the nursing home also gets $2,000, that could effectively mean that that spouse will pay nothing to the nursing home and the spouse at home will be able to keep it all. On the flip side, if you as the spouse are making more than that $4,000 amount, you could be subject to something called a support order. where the state says, look, you get more than the allowance we've determined community spouses need. And therefore, we are going to assess a support order against you. And so how they figure that out is they take the tax return and they have a chart and they determine the amount that has to be paid each month. And this is a payment directly to the state. It's not to the nursing home. I have had a lot of spouses who have been really concerned about that and really bothered and kind of turned away from Medicaid. And I say, well, that monthly payment is going to be far less than having to privately pay the facility in full. So it's still beneficial to you. I've also seen a lot of scenarios where the community spouse might not even ever get that order for whatever reason. The proper referrals aren't made, a caseworker doesn't do their job, and so they may never even become subject to it. But it is a possibility. So this type of rule could differ from state to state, but that's how it's applied in Illinois. Okay. Myth number 9. If I am married and my spouse moves into a nursing home, I will lose everything. This is a myth. So let's talk about what isn't counted when you have a spouse. So their home is going to be exempt. So if the spouse is living in the family home and their spouse goes into a nursing home, as long as they are living in that home, it does not count. So if they have equity of $300,000 in it, then it just simply doesn't count towards their asset limit. And there are other ways it could be exempt too, based on occupancy, but here we're kind of focusing on being the spouse in the situation of your spouse in a nursing home. So as long as they have an ownership interest in it and they are living in it, it's their place of residence, it is not going to count. A couple of the other exceptions, the disabled child, or the last one, this caregiver child exception, I use that a lot with families. And so that applies when you have a home. Let's say you don't have a spouse and the parent has to go into a nursing home, but there was a child who lived with them, provided care to them, and they did so for 2 years preceding their admission to a nursing home. As long as we can properly document their residency and get a doctor to state that they needed care during those 2 years, then we're able to transfer ownership of the home to that child, which is a very nice exception. And I think the logic behind the rule and the logic behind Medicaid even allowing this in the first place is that had the child not provided the care, the parent would have had to move into a facility, would have had to spend their money on the facility anyway. So this, in a way, is kind of compensating that child for the care that they provided for those 2 years. And ultimately, in a way, could have saved the state some money because it didn't have to be provided in a nursing home setting. So the community spouse maintenance needs allowance, this is what I was discussing on the previous slide. It is roughly $4,000, the exact number, $4,066.50. And this is where we can bring the spouse's income up to that amount. I have had spouses who have said to me, okay, it's all well and good that I can keep the $4,066.50, but I've got a mortgage, I've got a car payment, I've got other loan payments, I've got my basic expenses, and this exceeds $4,000. I need a higher amount. So a spouse can actually request a hearing on an administrative level or go to court and establish that they need a greater amount than $4,066. I've done this a number of times, done it successfully, but the key is that your spouse has to be able to demonstrate that they actually have those expenses, right? So we usually work with them. We pull a year's worth of bank statements, a year's worth of records to just kind of analyze what their actual spending is and determine how much they need. So you would want to do that in a situation where I think when I've done it previously, the spouse who was in the nursing home had a nice pension, probably, a pension where maybe they're earning $6,000-$7,000 a month. And so it's can really benefit their spouse at home to be able to transfer a fair amount of that to them to pay for their various expenses. So think $4,066.50, but you could ask to increase that if you had the right situation. So the community spouse assets. So when we are applying, all assets count. So it's everything owned by both spouses, even if they've kept them separate for years. They never jointly own them. It's everything in joint name, in separate names, or in the name of a trust for the benefit of either spouse. So everything is lumped together, everything counts. So the community spouse asset allowance is right now it's $143,172. So that's basically the amount, the limit for a spouse, and your exempt assets don't count towards that, but everything else that they have that's not exempt does count towards it. You can get a court order to increase that amount if you can demonstrate that you need more than that. There's also another exception called the refusal to support exception, where the spouse keeps everything in their own name. They sign a refusal to support, and then the spouse living in the nursing home assigns their support rights to the state, where the state could then pursue the spouse for what they paid on their spouse's behalf for their nursing home. Now, the advantage to this is that I've had a number of people where the private pay rate at the facility, so if the spouse were to just pay, right, using their assets and get themselves down to 143,000, that private pay rate could be almost double what Medicaid is going to pay for the same room. So by doing this, we're able to essentially allow the spouse to take advantage of paying the Medicaid rate instead of paying the private pay nursing home rate. So it can be an advantage in the right situation. So when you think of community spouse situation, everything counts unless an exception applies to a particular asset. All right, myth number 10. I can give all my money away and still qualify for Medicaid. This is a myth. And it kind of also does depend. So, non-allowable transfers. So in Illinois, Medicaid will look back at what you did with your money and property for 5 years before the date of your application. They are looking for you transferring your money and your property. They are going to penalize. They will say it is not allowable for you to transfer something for less than fair market value. Basically meaning you give something to someone and you don't get what it's valued in return. So you are getting less than fair market value. So this could mean, for example, you sell your house to your kid, but you just give them a deal, right? Instead of making them pay the appraised value, you just give them a deal. That's less than fair market value because if you had gone to the fair market, you would have gotten more than what your kid paid you for it. So that's something where you still got something in return, but it was less than fair market value. Most gifts are not allowable. There are certain gifts that the state has said are okay. So, for example, they have said, I think this may depend on who's reviewing, but they've said, your routine holiday, Christmas, birthday gifts that you've been doing for years, that's not something we're going to take a big issue with. But I still caution people that that's policy and that can change depending on who's reviewing. So I say, if you haven't really been doing gifts in the past, don't all of a sudden start doing birthday, holiday, Christmas gifts now, and try to keep things around the same as you were doing if you were historically doing them. If Medicaid were to find something that they don't like, a non-allowable transfer, it's going to cause a penalty. And so how this works is, let's say Medicaid found someone gave away $10,000 worth of money or property. They will determine the penalty by dividing that by how much the facility costs each month. So let's say that's $10,000. 10,000 divided by 10,000 gives us a 1 month penalty. So during that 1 month, Medicaid's not going to pay for that person's room and board at the facility. And obviously the facility wants to be paid. And if they don't get paid, they can move to kick someone out. So it's kind of like you got to figure out how their bill is going to get paid or they're going to get kicked out. I've also had people who will simply, as part of the application process, when we're analyzing their transactions, where the family member or the friend or whoever will just give that money back, essentially negating any penalty that could have been imposed as a result. I think with this, people will say, well, if I'm going to have a penalty, then I'll just make sure I have enough money to pay through it. Well, this penalty doesn't actually start. So that 1 month that I talked about doesn't actually start until the person is otherwise Medicaid eligible, as in they only have $17,500 of countable assets. So it's like Medicaid doesn't really start tolling it until you have nothing left to really use to pay if you're going to have a penalty. Now, for years and years and years, the asset limit was $2,000. Now with 17,500, if you had that 1 month penalty, you in theory could just dip into your 17,500 and pay it. But that's just not always the case, or your penalty could be much larger than that $10,000. So definitely a difficult spot if you are going to have a penalty and kind of trying to figure out a plan to combat it. Now, there are the allowable transfers. There are things that are not going to get penalized, even though maybe we would think, okay, that can't be allowed. So we've talked about the home. We have the ability to transfer it to a spouse, minor child, disabled adult child, or a sibling under certain circumstances, or that caregiver child exception. So we're always looking for those if we have the right situation, because being able to save a home, which is often the person's most significant asset, is a big deal if we can do it. Transfers between spouses are always allowable, right? So if the spouses have separate accounts and they're transferring money between each other, that's always allowable. And that's logical why it's allowable because, you know, Medicaid's going to count what each of them own towards the eligibility. So transferring it back and forth, it's not really going to make a difference. They're still going to count it, but it is allowable to do the transfers. So if you have a court order, and it's ordering transfers to a spouse, that's going to be allowable as well. To a blind or disabled child of any age, you can transfer funds to them. I think the kicker with that, though, is that it's very logical that the blind or disabled child might also be on benefits. And so if you just were to transfer your assets to them, it might kick them off their benefits. And so we oftentimes are creating a special kind of trust for their sole benefit, where we put the funds into the trust. It's used for the blind or disabled child, but yet it doesn't kick them off their benefits. There's certain requirements, there's certain kind of details regarding that trust. And so we've got to comply with those rules. But if we do that, which is totally possible, then we're able to kind of preserve that money for them. If you are under the age of 65 and you are disabled, you have what we call OBRA payback trusts or pooled trusts available to you, which these are special needs trusts, probably a more common name, where you can put your money into it and Medicaid's not going to count what you put in it because you are under the age of 65 and the trust is under the control of a trustee who decides how the money is going to be spent. It also will have to say things like at your death, the first order of business is for the trust to pay back the state for what they paid for you during your lifetime. So as long as the trust meets all of those requirements, it's a really nice planning tool for people who are under the age of 65. In other states, so for example, in Indiana, you can do one of these if you're over the age of 65. In Illinois, if you're over the age of 65, they're going to penalize it. So this is another thing that differs depending on the state where you live. And there's probably a lot of other states that have a more favorable treatment of them than we do here in Illinois. The last bullet point is kind of a catch-all, made exclusively for a reason other than to qualify for benefits. So I think where I've seen people actually be successful in arguing this to Medicaid I can just give an example. Young woman in her 50s had a car accident that resulted in her needing to have long-term care for the rest of her life. She applied for Medicaid, and during the 5 years preceding her application, she had done a number of gifting to her children, paying for things for them. And Medicaid said, you had no realistic expectation that you would require long-term care within the next 5 years of doing those gifts. This was essentially a car accident, unanticipated, and therefore we can conclude that you didn't make these earlier gifts to try and qualify for Medicaid because you could not have realistically expected that you would have need Medicaid within 5 years. It's a tough, it's an uphill one to climb if you want to just try and argue, look, I did that. It wasn't to qualify for benefits, because you've really got to have the facts and the circumstances on your side to be able to make that argument. All right, myth number 11. I can pay my daughter to be my caregiver and still qualify for Medicaid. It depends. So I always emphasize if you are thinking that you are going to need to pay a family member to provide care, you should have a contract in place with them because Medicaid presumes that care provided by family or friends is of the goodness of their heart and that they are not going to get compensated. And so you need to have a contract that predates them providing that care. They will also need to keep a log of what they're doing and be paid in a fair market way. So when I work with people on doing that, we'll kind of compare, okay, what is a caregiving agency charging per hour? And as long as all of those factors are met, you can generally pay a family member without any sort of an issue. So key there, think if a family member is going to provide it and you want to compensate them, make sure to have your contract in place before, pay them at a fair market rate, and have them log their time so that they can prove that they actually provided the services. Myth number 12, Medicaid is only for low-income individuals. Not necessarily. So it's for people who are going to be impoverished by the cost of their long-term care. We have a whole bunch, there are many assets that we can say are not countable. And so I went over a lot of them, went over kind of these ones that are on the slide, but it's really more about, are you going to become impoverished? And as I mentioned, to qualify for Medicaid in a long-term care setting, your income just has to be less than the cost of your facility. So, someone could have a $6,000, $7,000 pension, and we might not, just looking at them, consider them to be a low income person, and they would still qualify for Medicaid because they're not going to be able to pay the cost of their care just with that pension alone. They need help, to be able to pay it, and that's where Medicaid comes in. Myth 13. Medicaid means living in a bad nursing home. So I think proper planning can help kind of avoid some of those concerns. Making sure that someone has the appropriate documents in place, making sure that they have their estate plan, their powers of attorney, that they've explored special needs trusts if their circumstances are appropriate for them, and that they've documented what their end of life wishes are, what they want when it comes to how their care is going to be provided and where it's going to be provided. And so I think I've worked with families who have had people in a facility that only accepts Medicaid, and the care has been excellent. I've had people who have done a family member in a non-Medicaid accepting facility and eventually transitioned them and had no issues with the care. So I don't think that it is fair to say that if you're going to a place and you have to have Medicaid cover it, that it is a bad nursing home. I will say though, some nursing homes are better than others, and I think that's just the fact of the matter. So planning and making sure that you have your documents in place and you've explored these things before this becomes a reality can help avoid that. So the final myth, I don't need a Medicare supplement once I qualify for Medicaid. Yes, you do. There are benefits to having one, even when you qualify for Medicaid. I think probably the biggest thing on my end is I see it just opens up provider options because before any provider ever gets to billing Medicaid, they will bill Medicare, they will bill your Medicare supplement, and they might not even get to Medicaid. So it's going to open up provider options. When you say, okay, well, how am I going to pay for it? Well, let's go back to my person in the nursing home. They got to pay their income to the facility. They can deduct that diversion to their spouse. They can also deduct the premium for their Medicare supplement. So they'll have the income to pay it. They just send less to the nursing home, and the nursing home just gets paid more by Medicaid. So most of my Medicaid applicants do end up keeping their Medicare supplement.